to start in 1 minute. Okay, hello everyone. I'm Bob Mackey, President of the Niagara Landowners Association. We're the Niagara chapter of the Ontario Landowners Association, which is a group of volunteers across Ontario. We now have a group in Western Canada and in Quebec. We're fighting for property rights and trying to fight for what can restore property rights in Canada. We've always had property rights in Canada. It's just that they've been kept hidden from us. Anyway, we have some guests here today. We have Jeff Bogart's going to be the facilitator today. He's the president of the Niagara Landowners Association. He's also the vice president of the Ontario Landowners Association. Jeff has retired from a police force several years ago, and he's a very strong landowner. He's going to start the proceedings off. And then we have Cynthia Moyer, who is president of the Huron-Perth Landowners, and she's the CEO of the Cooperative Legal Services of Ontario, along with Terence Green, Green and Associates. Then our guest speaker today is Elizabeth Marshall. She's the head of research, or the chair of research for the Ontario Landowners Association. She's a director on the Canadian Justice Review Board, and she's a research fellow. It's the Meehan Institute for Public Affairs. Anyway, so what we're bringing forward today is information that everybody can use in their own personal lives. If there's any counselors here, that it's information that they could use to help protect themselves in the future. This information is it's printed in all the provincial acts: the Ontario Municipal Act, Species at Risk, Greenbelt Act, the Planning Act. All these acts have a common theme. It says that the government must enter into an agreement with us, or they must they must acquire lands to exercise their authority. But anyway, Liz knows all that stuff, and she studied all that. Take notes. If you've got a recording device, record all this information today, because it's very, very important, and there's going to be a lot to cover. So there's some notepads at the back that you can write on. This is the third seminar that the Ontario Landowners have put forward, and our Niagara group is hosting this one. The first one was in Carleton Place, at Carleton Place Town Hall. The second one was in Carp, Ontario. We had good turnout there, and we've brought forward this information for a lot of people, and it's starting to make a difference. So I'll turn this over to Jeff, and we'll get started.
Thanks, Bob.
Thanks, Bob. As Bob said, my name is Jeff Bogart, President of the Niagara Landowners, Vice President of the Ontario Landowners, and I will be your facilitator for this afternoon. And that means that I'm going to ask you to ask questions. Keep your question concise to about 60 seconds. If it starts to run on, I'm going to cut you off and have that question to the panel. We've got to keep this going, so it's not for me to stand up here and talk to you. It's for you to engage the panelists here, ask as many questions as you can, There's no bad questions here. If you have anything in your mind that you have, gee, what about this? Ask it. Because today, if anyone has sat in front of a lawyer at $300, $500, $600 an hour, and you're going to be here for the next 3 to 4 hours, that's $1,000+ of legal fees that you just paid $10 for. And that's a pretty good deal. The first thing I want to do a little chat about is the word belief, because I run into that problem all the time as I travel through the landowner issues in Ontario. Belief. I believe. And if we go back in time to Galileo, in 1610, he wrote a book called The Starry Messenger. And that put him on a path that was right up against the church. He was charged with heresy. And he was put in prison for an indefinite amount of time, which was commuted to a lifetime of home arrest. So after that, he spent the rest of his life under arrest in his home for what he believed in. But everything that he believed in, he did it in terms of science. He proved that the earth revolves around the sun. He proved it mathematically, he proved it through astronomy, and he even offered to the skeptics, look through my telescope, I can show it to you. But they wouldn't believe it. And so he ended up in prison. A little closer? How about that? Okay, is that better? The next thing is flat earth. People believe that if you got into a boat and you... How's that good? Yeah. Okay. That if you sailed out into the ocean, away from land, you would go over the edge of the earth. That's what they believed. And so it took many hundreds of years before we were finally able to cross the oceans without watching the land, the shoreline. And that's a belief. So how many people here believe that the sun rotates around the earth? Okay. How many people believe that if you sail out into the lake, past the shoreline, into the horizon, you'll go right over the edge of the earth? All right. Got 2. Got 3. All right. There were 4. There were 5. Okay. That's because you don't believe that. And you don't believe it because in your lifetime, it has been proven to you that it's not true. So I asked the question, if you believe that, then why do you believe you do not have property rights? How many people here believe they don't have property rights?
Certainly doesn't look like it.
Yeah.
Right? Today, we're going to prove to you, through the law that exists today, that you have property rights. How many people have gone down saying to your local municipality, I'm here for a building permit because I'm going to build a house? Right? Why do you believe that you have to have that building permit? Because somebody told you? Did you read the Municipal Act? So you didn't read it. Did you read the Planning Act? How about the Building Code? So you went down there to get that building permit because you believed that you had to get one. So when councillors pass bylaws that affect private property, and I have been told this personally, when I asked the councillor, have you read the Municipal Act, which is your corporate manual that governs your corporate municipality as to how you conduct the affairs, how you conduct its affairs of the municipality, not yours. That if you haven't read the Municipal Act, how can you pass a bylaw affecting private property? Did you read the Municipal Act? No. Are you telling me that you didn't read the Municipal Act, but you are voting on passing bylaws? Yes. Anybody else on council not read the Municipal Act? Yes. How many? All of them. So, nobody on council, this is one specific council, down my way, they have admitted that they have not read the Municipal Act, the corporate manual that governs the corporation of the municipality and how it conducts its affairs, which affects private property. But they believe that they can pass bylaws without even reading the legislation. A belief. So when you leave today, we want you to stop believing what you currently believe and believe what you have heard that stands in the law. Which we're going to do and tell you exactly what the law says, even though you haven't read it. We've all read how many hundreds of pages of legislation? How many thousands of hours of research? Okay. Too many. So that's the point I'm trying to make. Stop believing that what you're told is the truth by a municipal organization. We need you to walk out of here today saying, I'm going to change my belief about that. Now, everything that we tell you today, I want you to go out and confirm for yourself. You will have access to municipal legislation. Go to eLaws Ontario, Electronic Laws Ontario. Look up the Municipal Act online. Go to Section 8, Section 10, Subsection 2.4, Section 11, Subsection 2.4, Section 445.2, Section, and on and so on and so on. Look it up for yourself. And when you read it, you're going to say, what the hell? They can't do that. It says so right here in the Ontario Municipal Act. So why are they doing it? Well, the next thing you got to do is go to council and say, hey, why are you doing that? Well, we can do that because we believe we can do it. I don't think so. Not anymore. So that's the thing I want you to take away from today, is change the belief that you have in what you've been told. Confirm it for yourself. And then get active in the landowners, and get active in the politics, and hold your corporate municipal council accountable for their actions and whether or not they have actually read the manual that governs their actions. You know? All right. Next person up, Cynthia Moyer, who is president of the Huron Perth Landowners Association, chief executive officer of the Legal Services Cooperative of Ontario, and last year at the Ontario Landowners Annual General Meeting, Landowner of the Year, and Landowner Organization of the Year. Congratulations to you. Doing a heck of a job out there. What this lady is going to tell you is going to, as Liz would say, spin your head around. Cindy Moyer, ladies and gentlemen.
Thank you very much, Jeff. Good afternoon. Thank you for having me here, and thank you as well for coming out. Jeff's absolutely right. People out in the public don't understand what property rights that they have. Conversely, I find in my work as president of our chapter in Huron Perth that our municipal council members and staff do not know the legislation that they are purporting to give advice to the council on and or restrict property use on the constituents in their municipality. To me, that's a big issue. That's a very big issue. Because if you look at the 2010 Municipal Councilors Guide, if you read the legislation, for example, the provincial policy statement, it all says in there that the municipal council and I would say the staff inferred are to know the legislation. But there's, what, 80 pieces of legislation that impact municipal governance? There is no way that any one person, except for maybe the lady sitting on my far left there, who would ever know that legislation completely in its entirety and understand it. And by the way, I read a lot of court cases and a lot of court judgments, and over again the courts are saying that legislation is to be read in its entirety, not cherry-picked. And I find over and over again when I'm speaking to building code officials and when I'm speaking to planners, these are all the people that are hired to advise our municipal councilors in the lower tier and upper tier levels on what they can pass bylaws that bind us or seemingly bind us. They're advising cherry picking out pieces of legislation, but they're not reading the acts in their entirety, and they're not reading the legislation that goes with the act. So for example, recently I spoke to a chief building official, and I asked this individual, what pieces of legislation, in order for you to come up with your determination on this private property, are you utilizing? Well, the answer came back, the only thing I'm using is the building code. And I said, well, you're talking about zoning, so you're not bringing into account either the Planning Act, and you're actually referring to the zoning which was passed through a bylaw, and you're not referring to the Municipal Act? Well, I don't need to know those pieces of legislation. I think you do. I think you do. And because you don't know it, then you don't know specific aspects of that legislation. You don't know the intent of the crafters, the drafters of that legislation and what they intended. And if you don't know the intention and you're just cherry picking out pieces of legislation, then you're putting yourself and the corporation that you work for at risk. You're putting them at risk because you're not doing your due diligence to know your job and to know the duties of your job, which means that you must know all of the legislation that you're using the authority and power under. Because that's really where the authority and the power comes from, I learned, is through the legislation. That's the acts, that's our laws. So I'm really not going to touch very much on that too much today. I'm here to talk to you about what I'm doing, something that I'm really, really excited about. For the past 2 years, as Jeff said, I've been the president of the Huron-Perth Landowners Association, and I actually formed and started our chapter. And as president, which I'm sure you can, Bob, and you can attest to, being the president of a landowners association, one of the things that you get is phone calls day and night, 7 days a week, from property owners and people across your community and even outside of your community, asking questions. They've got problems. I got a stop work order put on my shed that I'm building on my farm. I'm trying to build a lean-to for lumber out the back of my house, and I've got the building inspector on my back. I got a letter from the county saying that I can't cut down trees and manage my bush. It just goes on and on and on and on and on. Problems, problems, problems. So it's really difficult in being in that position as a president of a landowner, because it's heartbreaking to actually sit at the kitchen tables with these individuals and listen to their stories and see the look of fear on their faces. To know that they're facing issues that could potentially bankrupt them if they fight it, that their ethical and moral values are being challenged because they know they haven't done anything wrong, but they've got a summons to court with a charge. And faced with a justice of the peace to essentially say, plead guilty, pay $1,000 fine and costs, and you can walk out of here, but you got a guilty provincial offense against you, or to fight it. And they look to me and they say, what do we do? What do we do? Well, first thing that I say to them is I'm not a lawyer and I don't give legal advice. That's number one. But then the second thing that they say to me is, I want to fight it. I want to fight back. I know I'm not doing anything wrong. My father and my grandfather owned this farm for years. This is a century farm. I'm harvesting the lumber out of my bush. I'm managing my woodlot the way my ancestors did for many, many years. And here I am. I've got a charge now here, and I got to go to court and defend myself. and I'm faced with guilty and an X amount of dollar fine from the county or the municipality, or I fight it and I have to remortgage my house in order to pay the legal bill. What do I do? To me, as an individual, that's the hardest. That's when the tire hits the road for me. Is when I have to sit across from the kitchen table from a man or a woman who wants to do what's right. A lot of the people that I deal with are, you know, in their later years in life, and they don't want to leave this earth knowing that they've got a black mark against them by their neighbors, by the public, saying that they did something wrong, and they know that they didn't. So to me, I've been racking my brain for the past 2 years to try and find a solution for that. And I think I found one. But I had help. So what I've been working on all summer long is called the Legal Services Cooperative of Ontario. And if you're familiar with the cooperative model, that is member-owned, member-controlled, member-driven. It's private. It's not open to everybody. It's the members that actually own it. So as Chief Justice Beverly McLaughlin has been walking and traveling across Canada telling anybody and everybody who will listen, is that affordable justice is not available to most medium-income Canadians. That's a problem. If we can't afford justice, is there justice? If it's barred from us because we have to face a choice of, do I defend my rights and take out a second mortgage on my property in order to do so, or potentially lose my property? I don't know how many people I know who have gone bankrupt in litigation. To me, as a person living in Ontario, I think that's really, really wrong. I do. So in order to find justice, I think we can solve that problem. And how we can solve the problem of cost is to address it entrepreneurially. Because we create it. We build it. We create it. We own it. We control it. That's the solution. And we follow an over 100-year-old model that started in the UK in the mid-1800s, and that's the cooperative model. As I said before, that's membership. If any of you here are members in the Ontario Landowners Association, or the OFA, or any other organization, you already know what membership is about. So in the Legal Services Cooperative of Ontario, which is in the process, which we are in the throes of becoming incorporated through the Financial Services Cooperative of Ontario, we need to have a nod by the Law Society of Upper Canada and make sure that that we meet their needs and criteria as well. But this is going to provide cost-effective services for our members, and our membership is across Ontario. So though our offices are located in Ontario, our hope and our goal is to grow and have branch offices across Ontario, but regardless of where we're physically located, we will be helping anyone across Ontario, regardless of where you live. So low cost, our two number one mandates are low cost legal services, high-end services. So one thing I want to make clear today is that I am not here to cast doubt or any sort of negative feelings towards lawyers. I happen to have very, very, very high regard for a lot of lawyers, and I talk to them on a regular basis, just simply being the president of the Landowners Association and with all the research and that I do. I have very high regard for lawyers. What I don't have high regard for is our legal system that has set in place a barrier to affordable justice and affordable legal services. That's what I have an issue with. It's the system that has allowed that to happen. And I would venture to say that I think, it's my belief, and I'll use that word, Jeff, my belief that Ms. McLaughlin feels the same way, is that we need to look at a new way of doing things. And I think that's how we're going to solve this. We're going to do it. We're going to do this together. And the Landowners Association is behind this extensively. And the Landowners Association members are the ones that are coming on board in droves to support this, because we get it. We know that there's imbalance out there in the legal system. We need a game changer. We need a leveler. And this, by and large, is a leveler. And so I'm really, really excited about it. And I have some information here today to share with, I don't have a lot of information because we're actually opening our doors October 1st. So everything, marketing material, everything is just right now in the works. We just recently got our 1888 number and website, and all of that's being worked on. So this is kind of like, for me, I feel like I'm running alongside a train trying to keep up and to this locomotive that's just left the station and is picking up speed. So for me, the challenge right now is to keep running with it. But I'm absolutely, completely overwhelmed by the amount of support that's not only coming from the Ontario Landowners Association, but the chapters, and thank you, Bob, and the Niagara Landowners Association for giving me the opportunity to come down here this afternoon to talk to you about it, because I'm really, really excited about it, and I can't say enough that I think it's a game changer. So what are we gonna do? What are we gonna provide? We're gonna provide legal services, but we're gonna provide them at a cost-effective way for our members, so that you can get access to justice, so that you can get access to legal services from anything, from purchasing real estate to selling real estate to having, launching a claim against someone, to collections, to pretty much anything that you would go through a normal legal firm for. The difference is that it's not the partners in a law firm or the lawyer, if it's a single solicitor within a law firm, that is gaining the profits. It's the members. So if any of you belong to a cooperative type business or a credit union, agricultural cooperative, you'll know that dividends, if it's a share capital cooperative, are returned, excess dividends that are declared by the board of directors are returned to the shareholders. So members purchase a share, and the other thing that I really like about the cooperative model is it's one member equals one vote equals one share. So if you look at the standard corporate model, you will have perhaps an owner or a group of owners, and if it's a publicly traded corporation, those owners are shareholders that could be anywhere across the world. They could be in Taiwan and own, a majority of shares in a corporation that's right in your hometown, but they have never been there. They don't care who we are or what we're about. They don't get involved in the community. All they do is hold shares. And the minute that those shares drop or that they see a better opportunity, they may pull those shares out of the corporation, or a significant portion of the shares out of a corporation, and invest them elsewhere. Well, what does that do for your community? Do those shareholders really care whether or not, you've got massive school closings in your community, whether or not you've got lack of facilities for your youth to play? No, generally not. They're more interested in profit. But the thing about a cooperative is they're interested in people, the planet, and profit. So they understand that there's a connection between all of them. So cooperatives are very, very community driven because they're owned and controlled by the people who utilize the services. And cooperatives in and of themselves are twice as successful in terms of business success than any other business out there. So if basically they look at what's the success rate of a business within 5 years, 10 years, 15 years, basically they say if you make it after 5 years, you're doing good. If you make it after 10, you're basically in there for the long haul. Cooperatives, compared to other types of business models, are twice as successful. So, again, low cost, high service. How many people have ever used a legal firm or had a problem or purchased a house or sold a house and you've had to phone your lawyer or your paralegal or whoever you were working with and hound them to give you information on where your case is or where your sale of your house is or where anything is? How many of you had that issue? Yep. So one of the things that we are working towards addressing is that very issue. Because for us, our members are our whole reason for being. And if we're not giving our members top-end service, then we're not doing them justice. We're not doing them good works. So one of the things that we'll be building in is almost like a project management in what we do. So that our members are never having to hound us and chase us, you know, what's happening on my file? What's happening on my issue? Have you gotten a letter from so-and-so? So that we can actually turn that around so that our members are getting updates regularly on what's happening with their file. So that it's never that they have to come to us. To me, as the CEO, that would not be a good thing. That would be a negative thing for our members to have to hound us to find out what's happening. How's the sale of my house going? Did you hear back from their lawyer? Have you gotten a letter back, you know, from their lawyer? Is the sale going to go through? Is the septic system all okay? Is everything, you know? To me, that would not be a good call. I would rather we call our client and say, we got a letter in, here's where we're at, this is what we're doing next, we'll get in touch with you. I want our members to say we get the absolute best service, best legal service through the Legal Services Cooperative of Ontario. So again, low cost, high service. One of the questions that I get asked all the time is, how are you going to give low cost services? Well, the first thing that I say is forget everything that you think you know about a legal firm. I can't think of calling ourselves a legal firm because we're not really going to operate exactly 100% like a legal firm. Because as I said before, we're not from the beginning, we're a cooperative. It's not where a group of partners, you know, share in the profits of the corporation or a single, you know, proprietary solicitor. As a cooperative, it's member-owned, member-driven. So the first thing I say is, don't think about a law firm and your experience with a law firm, because our goal is to be different. Different within the rules, of course, of what's required of us. We will actually be there's a Cooperatives Act in Ontario that we must adhere to. We must adhere to the rules and regulations of the Financial Services Commission of Ontario. And as I said before, because we will have lawyers and paralegals working with us, we also have to adhere to whatever requirements that the Law Society of Upper Canada has for those individuals. But by and large, I want you to remember that our goal is to be different. Extraordinarily different. And so I say to them, imagine if you owned a hardware store. And imagine if next door to the hardware store, there was a liquor store. And you own the hardware store, and the neighbor across the street owned the liquor store. He needs hardware, you like scotch. Okay? So it's different when you own the hardware store. Are you going to pay as the owner of the hardware store retail for that hammer that you take off the shelf? Or are you going to charge yourself cost, or are you just going to kind of work it in somehow? you're not going to pay the retail price for it, are you? No. You're going to give it to yourself at cost or do something as the owner of the property or as the owner of the hardware because you're the owner. It's yours. You can do as you wish with it. You can dictate what the cost of that is going to be based on what your expenses are, based on your income and profit from your business. You control it. You get to dictate. Now, if you go next door to your neighbors and you go in to buy that bottle of scotch, unless you know them real well, you're going to pay the sticker price that's on the shelf that everybody else pays. There's probably a law about that too, that you can't sell it for anything less than what the sticker says, but anyways, you kind of get the picture. That's how we're going to be innovative. That's how we're going to do this. And as I said, I truly believe, and the members that we have already joining, is that it's going to be a game changer out there. Some of the other questions that I get is, you're going to grow so fast that you're going to put lawyers out of business. And I would say absolutely not. If anything, I think it will improve litigation within the province. Because people, instead of bailing on defending their rights and bailing on, making challenges in the courts or finding justice, they're going to all of a sudden have an affordable way to do that. So you need an opponent out there somewhere. So my answer is I don't subscribe to that. I think it's actually going to provide people who, the majority of Canadians, as Chief Justice McLaughlin says, that don't have access to affordable justice. I think this is going to give them that access to defend their rights, whether it be for property, whether it be for anything. And as I said before, not only that, I have people who are coming to me now with questions. Can you set up, we have an organization, and can you set up a trust for us and manage that trust? Can you, I have a corporate minute book. Can you, update our corporate minute book? And I say, anything that a law firm would do, we can do. But only if you're a member. That membership purchase share gets you access to the services. And when people say to me, well, is it a fee? I say, no, it's not a fee. It's a one-time share purchase. You're purchasing a share. And as long as you have that share with the cooperative, you can utilize those services. There is a limitation currently of 24 months that you cannot withdraw your shares. And there will be, through the Board of Governors or Board of Directors that we have, there will be very shortly put in place a limitation as to the number of times you can join and pull out your membership. And I should say as well, if you pull your membership share out, you get your full membership share out, purchase cost, plus any dividends if they've been declared owing to you. So I say to people, you're essentially purchasing a share and investing in something that I think will change the face of Ontario. Because imagine the majority of Ontarians suddenly having access to justice and affordable legal services. Now, I should say, when I was looking into doing this, I did some research, of course. I wanted to know, has anybody else done this before? So I looked across Ontario and no legal services cooperative. I looked across Canada, none. I looked through the US, none. So nothing in North America. So then I looked across the ocean, and one other legal services cooperative has started in the world that I could find through the internet search. And that's a legal services cooperative in the UK. And just to give you an idea of the scope of what this could potentially be, this legal services cooperative in the UK was founded in 2006. sometime in 2006. I don't know when they actually opened up their doors, but they were founded in 2006. In the Financial Post, in March of this year, which is a Canadian financial paper, they did a report on this cooperative in the United Kingdom, in England. And in that article, they did a report on the 2012 year. Okay, so less than 6 years that this cooperative was up and running. They have over 500 employees. And in the next 5 years, they plan to hire 3,000 more. That's how successful it is. And if anyone has ever started a business or knows anything about business, that's remarkable to have that kind of success. So to me, I looked at that and said, yes, there is a market for this. That is a solution. And when people find out about it, they want to be a part of it. Even if they don't have a problem currently. They're looking at it as insurance, number one, against whether they do have an issue or not. Number two, they're looking at it as a resource that is currently barred to them because of high cost. So they're looking at, hey, I got a contract in the mail from my cable company, and this thing is massive and I'm not sure what I'm signing here. You know, I'd like to have a legal mind look at that. So all of a sudden, as being a member in the cooperative, they know that that's not going to, ding their pocketbook hugely to get that looked at and to give them a legal opinion back. So that as well. Third is that they're joining together, and as a landowner member, I think this is one of the strengths of the Landowners Association, and those of you who are landowner members in this room will totally understand this, is that working together, standing together, arm in arm, linked together, we are a force. We change things. We can't look to government to change things for us. That's not going to happen. Has it worked for us so far? No. If we want things to change, we have to make it change. And we do that together. No man left behind. That's how we work. That's being a Canadian. That's what my ancestors came here from England many, many years ago to do. That's how they worked, that's how they survived, that's how they thrived, and that, ladies and gentlemen, is how we're going to deal with the issues that we're facing today. Together. And if you walk out of here today with any thought in your mind, I want you to leave with one thing. You can. We can. And we will. Thank you.
Thanks, Cindy. Chief Justice Beverly McLaughlin, 71 years old. She has mandatory retirement at the age of 75, and she has stated that she will go until she's 75. Chief Justice Beverly McLaughlin is the longest sitting Chief Justice in the history of Canada. And she can be seen on YouTube. And if you want to see more about what her thoughts are on affordable justice, because she has recognized and she has written reports that the people of Canada are not being able to get affordable justice. That it's just too expensive. And as Cindy says, people are just paying the fine, even though they're not guilty, and moving on because they just can't afford it. So, you are not alone out there. Chief Justice of the Supreme Court of Canada is backing you up. Join the landowners, get involved, get into the co-op. You're not alone out there. The next person up is Liz Marshall. How many people here have heard Liz speak before? Okay. Then I'm going to make a comment that what you see up front here, in my personal opinion, is a future recipient of the Order of Canada. For those of you who have not heard her speak, after she's spoken today, I want you to come up and tell me if I'm right or wrong. Liz Marshall.
Hi, everybody. Thank you all for being here. Thank you, Cindy. It's needed. Ladies and gentlemen, okay, so we've heard Jeff talk about councillors and mayors. We've heard Cindy talk about the legal profession and what's going on with that. She also mentioned about the 80 pieces of legislation. So I'm going to start with the Councillor's Guide from 2010. Because I'm not going to be beating up councillors. I know you're all going, pardon? No. We have elected these officials to do the best that they can. Some of them are really good people and they're trying very, very hard for you. Okay? Let's be clear on that. There are some people that we elect, they're in it for themselves. And throughout this province, I have actually witnessed myself some serious violations during public meetings, to the point that no one was misbehaving, and yet the police were brought in so that no one would ask a question that the council or the planner did not want to hear. Nothing like intimidation. Now, the reason for this seminar is I have been studying and studying and studying the Municipal Act all the way back to the original one, and it was referred to as the Baldwin Act of 1849. I have been studying the Planning Act, which was created in 1946. I have been studying the Conservation Authorities Act, which actually, the first one was the Grand River Valley Commission of 1932. I have been reading the Hansards, which is all of the debates at Queen's Park, to know and understand exactly what our legislators wanted these documents to do. I have studied every constitution we have, from 1763 all the way to the present charter. Then I went back and I pulled out all of the Magna Cartas. Everyone thinks that Magna Carta is one document. Magna Carta is 1215, 1216, 1217, 1225, 1235, 1253, and 1297. I have gone through the forest charters. 1215, 1217, 1297. I have read the Boundaries Act from 1641. If anyone knows anything about computers, I have 214 gigabytes of information on your rights. And I was put on to the Board of Directors of the Canadian Justice Review Board because I'm considered the foremost expert in Canada on the letters patent, Constitution, and basically municipal and conservation authority law. I am not a lawyer. I'm not giving legal advice. And I need my bottle of water. Anyways, the Municipal Act. Our councillors, in the Councillor's Guide from 2010, are told throughout the entire document, ask staff. Ask staff. Ask staff. And when it comes to lawmaking, well, you can receive information from staff, but staff cannot give you legal advice. Now, everybody's going, oh, those bad staff members. It's not those bad staff members. I'm going to go right back to the seed of the problem. The seed of the problem in this province is municipal affairs in Queen's Park. We have proof. Cindy, how many times did you bust municipal affairs? Twice she has phoned into municipal affairs and they were wrong about the act that they are supposed to be professionals on. I did this going through an MPP's office and they were wrong. So not only are they giving the CAOs of our municipalities erroneous information, they are giving our provincially elected officials bad information. Now, I'm not here to hurt anyone, but under the Municipal Act, the municipalities are merely corporations. Section 4 of the Municipal Act. Now, Cindy has done a really good job explaining what a corporation is. A corporation can only deal with its, and that's under Section 8. Its is ITS, big word. Because it is the term its means belonging to. So it can actually only deal with what belongs to it because it's a corporation. You as the residents are shareholders of that corporation. You elect the board of directors, which is your council. But if you are a shareholder in Canadian Tire, and you elect the board of directors of Canadian Tire, does that give Canadian Tire the right to tell you what you can or cannot do with your private property? Does that give Canadian Tire the right to demand licenses and permits from you? Now everybody's going, well, there's the Conservation Authority Act, and there's the Building Code, and there's the Planning Act. Nowhere in that Planning Act does it say they can plan for your private property. And that's without a word of a lie. Read the document. I particularly like the term in Section 14 and 17 of the Planning Act, which states, if they can plan. Section 24 of the Planning Act deals specifically with public works. Section 25 is the criteria, there's statements of acquisition for holding properties. When you read Section 25, go down to Section 34, subsection 8. Acquisition of lands for holding purposes. So we have planners placing holding symbols on people's private property when they legally cannot. The municipality has to own that property before it can place a holding symbol on it. And that ties into Section 36 of the Planning Act. Part 4, Section 28 of the Planning Act states community improvement. Community improvement, the first two words in the definition of community improvement is planning and replanning. And anything that it is deemed for planning or replanning is a community improvement, and they have to acquire the property before they can initiate any community improvement. And if you go into Section 1 of the Municipal Act and you look up economic development, again, they must acquire so that they can implement this economic development for commercial, industrial, or institutional purposes. Back to Section 28 of the Planning Act, That is, if they want to create social housing and so on and so forth, they have to acquire the land. There is nothing in these documents that says they can plan for private property. And I think the Midland Free Press in 2000, in regards to Roundtree Beach Association, said it the best. You can't plan for it if you don't own it. Now, I actually, I went to a meeting one night, and it was an official plan meeting. And this is how bad it's gotten. So, this municipality had their public meeting for their official plan. And I got called 3 days before. So I burned the late night candle, and I read through the consultant's report. And then I researched the consultant company that did the report. And I'm looking at this and I'm going, wait a minute. Because this report was supposed to be used as the advice for the municipal council to pass their official plan. Well, if they had just used this document, if a few of us hadn't shown up, and we weren't harsh, we weren't loud, we weren't anything, we actually had discussions. It was an open, good council meeting. And what came out of this was OMAFRA refuses to release how they determine the amount of agricultural land in these official plans. And so the municipality had already contacted OMAFRA and said, well, you know, we don't feel that this percentage is right. And we want to know how you came up with these numbers, and they don't have to give that information because it's supposed to be a licensed computer system. But they said if you don't like it, it's your official plan, so you can just use whatever numbers you want. You can do 60-40, 30-70, 15-85 if you want. Talk about arbitrary. So then, with the consulting company, this consulting company actually was a peer review company for another planning company. And this is actually going to maybe make you laugh. So the other planning company, they were doing a plan for a landfill site. And they had done up this big, beautiful plan and everything else, and they had presented it to this company and said, look, we want you to peer review it. So I started going through both of these reports, and I found a few gaping holes, but the biggest gaping hole I found was that the company doing the report for the landfill site said, this meets the criteria of the Woodlot Conservation Act. Now this report was done in 2008. The Woodlot Conservation Act was repealed in 1998. So of course it's going to meet the criteria of the Woodlot Conservation Act. Now that really upset me, because as far as I'm concerned, that left that municipal council that passed those bylaws wide open for litigation. No one is actually caring who is going to be the person that gets nailed for all of this. Now, so if we start going through the Municipal Act, Section 1 is all of the definitions, except for a few key definitions, which, continuing to read through all the different pieces of regulation that go with that Municipal Act, I have found. And there are two key definitions that are really missing. And that is a private person, which is in Regulation 59906, and the definition of a municipal property asset, which you will also find in Regulation 59906. Because Section 2 states, our municipal councils are to be accountable and transparent governments. Because every corporation has a government. That's what the board of directors is. And every corporation can create corporate bylaws. Section 3 states that the municipalities, 3 and 3.1, state that you as municipal councilors may enter into agreements with the province and or the federal government on your own. Section 4 states you are a body corporate or corporation. And then Section 4 refers you to Section 9. Section 9 is a key statement in that act. Section 9 states, you have the same rights, privileges, authorities, and capacities as a natural person. Now, myself as a natural person cannot come and tell you what you have to do on your private property. Correct? So,